So it's a great honor. Let us welcome Saha sir. I would call him Saha sir because he's called the father of IP in India. And the women scientist batch for turning out IP professionals in India was his brainchild. Okay, so he deserves a special mention for that. And going on to more formal introduction to his, he has a lot of feathers to his cap. Recently, he's a senior advisor at the Confederation of Indian Industry, that is CII. He has experience in policy design and development, IPR policies for institutions, technology evaluation, regulatory affairs, developing IPR centers, evaluation of patentability of inventions, patent searches, IPR advisory, auditing, international negotiations, teaching of IPR, including course development. Advisor to various government agencies such as Department of Electronics and IT, Indian Council of Medical Research, National Research and Development Corporation, Department of Science and Technology, IIT Delhi and Kharagpur. He has delivered around 600 to 700 lectures on various aspects of IP in Bangladesh, Sri Lanka, Indonesia, China, Mauritius, Egypt, Namibia, Oman, and Mexico. So over to you, Saha sir, and you are privileged to listen to him. Please keep your questions open, as many as you can. And this is a topic which not many take. So be receptive to it. Over to you, Saha sir.
Thank you, Vinita, for kind words. Participants, when Vinita asked me to speak on this topic, I was a little hesitant because it was not being covered by many people. But then I thought that maybe somebody has to cover it because the whole subject area is very relevant for the modern day technology, which is so widely dependent on digital economy, digital technology, and so on and so forth. Now, considering that, I think the IC layout, for that matter, I'll explain to you what it means, or semiconductor devices which are very closely linked with each other. They have some very special features on the IPR domain, and they really don't follow the same norms. What, if, for example, a patent or a IP related to drugs and pharma are going to follow. This because of some special features, because of very, very large investment, the industries and the companies look at these things in a little different manner. So you have to really look at from a little different perspective, in the sense that it is not only in terms of protection and registration, but to understand the overall let's say the fundamentals of these technology in the IP domain have to be looked at from a different point of view. So I'm going to try to explain to you. I don't know how far I will succeed, but it's a subject matter which is very challenging today, and there is a lot of discussions which are going on globally, whether the present laws regarding layout designs and other related devices are adequate or not. If they are not adequate, what is to be done? So it's a ever growing area. Now, if you look at the semiconductor devices, I believe there are people from computer sciences and big data area. Now, the whole concept of semiconductor devices started in, let's say, 1951 or 52, when the first time transistor was invented or discovered. And then it went on to move into ICs and VLSI and so on and so forth. And with each progressing day, the importance of these semiconductor devices has really transformed the whole world, the way we live, the way we think, the way we teach. Everything has undergone a lot of changes. And this is perhaps the only industry in the world which has been growing for the last 4 decades, almost at the rate of about 15-20% per year. So it's a very interesting area. Can we go to the next, please, Vinita? Now, you must have been told about these various different forms of intellectual property rights. Just to put the things in perspective, I'll just go over them again. Patents are basically the rights which are given to you for inventing something, some process or product. It is dealing largely with how you implement an idea. Okay, so idea per se is not a subject matter of patent. Then you have got copyright, which deals with literary, artistic, uh, and other subject matter, including computer software, films, TV. Now, copyrights deal with how you express an idea. I'm sure there is a lecture on copyright. You'll get to know more about it. But in the context of IC layout design and semiconductors, copyright is also an important area. Trademarks, of course, these are the name given to various products which are marketed by companies so that their clients can identify the product with the company and take a call whether the product is of the right quality as far as they're concerned. Then we have design, which deals with external appearance of an article, like you can have different shapes of mineral water bottle, which you must have observed. Then we have the GI, or the geographical indication. These are the names associated with products which are originating from a very specific geographical location, and they have built reputation over many years. And then we have the layout design of integrated circuits. This is basically in simple terms, whenever we talk about chipset or very large scale integrated circuits, this is where the layout design plays a very important role. Then we have protection of undisclosed information, which are dealing with trade secrets. And on trade secrets, if you have not already have an exposure to trade secrets, then it is something, the information, data, the concept, the presentation, the dies, the formula, the software, your employees' data, vendors' information. Many companies want to keep them as secret so that they are not known to, they don't make it public, especially for their competitors. And then we have the protection of new plant variety and farmers' right, which is largely of to protect agricultural inventions, uh, dealing with basically new plant variety, and we don't have time to explain those things. But these are the 7 or 8 different forms of intellectual property rights. And whenever we look at any technology or any product or a process, the best management part would be that you explore whether your technology or a product as such can get protection in all these different forms or not. Now, if you have a product of that kind, then you are quite safe in the marketplace from the point of view of competition, number one, also for getting an exclusive or monopolistic position in the market, and also increasing the share of your market. Uh, so for that matter, I'll just explain to you a very simple thing. Uh, you take a fountain pen, okay? Now, if you consider the ink, now ink itself is a chemical, and if you have an ink which can dry in, let's say, half a millisecond, it becomes a case for patent. The drawings which you make to produce that pen, engineering drawing, that may be subject matter of copyright. The name you give to your pen, let's say pilot or whatever, that becomes your trademark. There may be the external shape of the pen, and you will see that many ballpoint pens have very different shapes, although they are not very different from each other, but still they have different shape. That would be a subject matter of design. Uh, then you have, if you put a small watch on your pen, it may be matter of layout design, or the small IC will have to be used. You want to keep the colors which you provide to your pen. For example, if you extract these colors from natural dyes, and you don't want to disclose the plant name from where you extract these dyes, then that becomes your trade secret, and so on and so forth. So it's important since we are talking about IP management, this is a very important aspect which is often missed on the kind of a variety of rights which are given to you, which are possible by the given to you by the government, how you exploit all of them. Next, please. Next. Next. Yeah, okay. So go to previous. So looking at ICs, uh, integrated circuit is in the heart of a semiconductor device. And I'm sure students who are, or the faculty who are from this discipline, they know what this really mean, but there are people other than computer science or electronic background. For them, it's necessary to know that IC is in the heart of semiconductor device. These are some broad picture. Semiconductor technology is at the origin of today's digital economy. In fact, it's a common cliche that whenever we talk about digital economy in today's context, all the time what we are saying is of software. But please remember that for any software to work, it needs a hardware, and that hardware is usually is a semiconductor device. And what semiconductor device contain, we will see it little later. Semiconductor industry has been growing for more than 4 decades, and today it's a $4 billion industry. And another interesting aspect of the semiconductor industry is that it spends something like 18 to 19% of its sales expenditure on research and development. It doesn't happen in most of the industry. Perhaps it happens in the case of drugs, uh, and that too also in the area of, let's say, biotechnology and now biopharmaceuticals. Uh, so it is inconceivable to think of a digital technology without semiconductor devices and ICs, because ICs are integral part of semiconductor devices and chips. The other aspect, when you make semiconductor devices which contain large number of component, about the Moore's law, how the how the number of transistors which can be accommodated in a chip. The prediction was it will develop every 2 years, but I think it has gone much more than that. So we need a new Moore's law or some other law to predict the growth of ICs. And the semiconductor devices are also usually called chips. The disadvantage of a chip, okay, uh, is highly complicated. But at the same time, if you want to copy a chip and you have got some essential technologies, then the cost of copying may be a fraction of the cost of developing that chip. And this poses a, a very unique problem for the manufacturers of semiconductor device. So these are some base parameters you have to just keep in mind and see where they apply and how they can be applied. Next, please. So when we talk of digital technology, it's a very set of very complex technologies, and complex technologies in the modern parlor of interpretation has a meaning that the technology consists of a large number of patents, uh, possibly widespread patent ownership. That means these patents are not owned by one company, but they're owned by a large number of companies coming from different countries, and they have certain other essential feature would be that they are according to certain standards. So the sectors which are influenced by complex technology, or the sectors which will fall under this category, would be telecom, software, audiovisual, optics, smartphones. And a smartphone, if you take, which you normally use, contains something like 250,000 patent claims. To simplify it, it would mean something like about, on average, 8 to 10,000 patents. So a smartphone which you use is covered by something like about 8 to 10,000 patents, and hence you can imagine the number of inventions which have gone to protect that smartphone. And this is considered complex technology, and there will be other examples also. Even a laptop will fall under this category, but laptop is not that complex as if you take a smartphone, or even for that matter an IoT device. Next, please. So what are the areas of technologies in the digital space? One is the hardware. I mentioned it earlier. Hardware would mean, you're talking about sensors, advanced memories, processors, adaptive displays, semiconductors. In fact, sometimes the sensors are also built into semiconductors. Then you have software, which would mean cloud computing, storage, adaptive databases, and virtualization. When you talk about AR and VR kind of a thing, then connectivity, which would mean network protocol. Uh, how when you network basic connectivity, basically when you two persons holding smartphones or any mobile phone, they are able to talk to each other. So it has to go through some network, and how this network operate is a subject matter of high technical skills, because whatever you speak should the other side should be able to hear it in something like about less than 100 milliseconds, and with least disturbances or noise, so that you are audible, and also other side can comprehend what you're talking. So these are matter of high technical skills of electronic engineering, mathematics, network engineering, and so on. Next, please. Then you have the area of analytics, basically, how you handle data to meet your end. It's a subject by itself. People in the working in the area of big data, they know, and perhaps one of my slides is going to talk about it in a very simple term. Then we have the AI technologies, mainly machine learning, neural networks, and so on. You have position information like GPS. This makes sense in the context of a smartphone, power supplies, and security aspects of any communication or any data sharing, which is becoming all the more important when we are talking about in terms of personal data security. Next, please. So that was a broad introduction, if I can say, about ICs and semiconductor devices. But what are ICs? ICs are basically you create an electrode on wafer of a semiconductor material, like for example silicon. Okay, so that is what essentially IC is. And what you start thinking from transistor stage, where transistor, when we were studying engineering, there used to be small kind of a register, a small cylindrical thing, and we said this was transistor. But now in case of ICs, all these transistors are actually created or generated on the wafer, and different layers of wafers are arranged to create a semiconductor device. Next, please. So this is just an impression of that. This is a picture of a chip from inside. You can say how complex it may be. If you really want to know what this chip may be, we have been talking about different types of computers. So if you wanted to, even today, if you are thinking in terms of a computer to handle large data, for example, if you have a GPU or something like NVIDIA kind of system, so you will have a large number of parallel computers to handle various large data, which is in terms of petabyte, and then accordingly you handle that information through your software and other things. But today, a company called Cerebras, they have been able to generate an IC on a 12-inch diameter silicon wafer, and this particular chip can actually accommodate close to 1 trillion transistors, as compared to less than billion transistors according to the present technology. But with Cerebras technology, of course, it's going to take some time, but this is how things are happening. And as a result, if you're able to manage 1 trillion transistors in a 12-inch wafer, which would mean that you are also don't need separate parallel computers or processors, because everything can be built on that chip. It has got some negative effects, so we will not go into that. But the point I'm trying to say that the whole ecosystem or the spectrum of technologies are so very well dependent on semiconductor design and IC circuits. Next, please. So here are, as you remember, that I showed you a slide, different forms of intellectual property rights. So there is one form which is called the IC semiconductor IC layout design protection. So there is a law now. Okay, like any other, like you have a patent law, you have a law on copyrights, design, etc. So there's a law on semiconductor IC layout design, which came into India in the year 2000. And this was a very, very new thing for India, because first of all, we didn't have a semiconductor industry in our country. And all the more, we didn't know that some laws of that kind also exist somewhere in the world. Now, this was something which was a subject matter of TRIPS, that is trade-related aspect of intellectual property rights, which is a chapter of WTO, the World Trade Organization. And then any country which became a member of World Trade Organization has to have a law on protection of semiconductor IC layout design. In US, the semiconductor layout layout is so important. So without protection, nobody wanted to proceed. Has been there in some form or the other for the last 50 years, 60 years. Then there was a problem, the international problems to keep piracy or copying of semiconductor chips by different companies. There was some discussion on how to evolve a common law in the sense which can be accepted by various countries, so that piracy or counterfeiting of chips can be reduced. US had, as I mentioned, a very, very different setup things. They never thought, they don't think that they require a layout design protection, and they don't have any law, but they did have a Semiconductor Protection Act, which was there in the 60s and 70s. So the international community decided to discuss these things, and a treaty was signed in 1989 called the Washington Treaty 1989, which was primarily on protection of semiconductor IC layout design. And interestingly, the treaty was signed in Washington, but US is still not a member of this treaty. So still US has a different way of looking at things. And today, what happens when you look at it, and there is a distinct kind of dissatisfaction with this form of protection. The IC layout protection, that means how I'll come to the definition. And the number of protections, if somebody studies this thing, that how many sort of rights have been given for the IC layout design under this concept, it's actually reducing in many of the countries, especially in Germany. It has come down from something like about 900 to something like about a 2-digit number in the last 10 years. So layout design as such is a layout of transistors and other circuitry elements, and includes lead wires connecting such elements and expressed in any manner of a semiconductor IC. So good definition, or perhaps bad definition also, that does not make things very clear. We'll see how other people have done it. Semiconductor IC, a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside a semiconductor material and designed to perform electronic circuitry functions. So I've been telling to you about semiconductor IC, but what happens, so by using some special lithographic techniques and making mask of the pattern which you want to have, you create a very, very highly miniaturized circuit, which you can't even see with your naked eyes. You need special devices to see that circuit, how various components of a circuit are arranged and how they are connected. It's a quite a complex, very, very complex technology. So in one wafer, if you consider is a uniplanar wafer, it may contain millions and billions of transistors, but it can also have resistors and capacitors and electronic engineers, where you can load or complete an operational amplifier. You can also have a gyroscope built into your chip as you have in your smartphone. So the technology becomes a very complex. So when you make actually a semiconductor, it cannot be only one chip. It can be multiple wafers, but it can be one chip. But there will be multiple layers of wafers in which you put various components during the fabrication, and then you connect various layers to come up with a one single chip. Next, please. So this is a definition which I like quite a lot, which has been issued by the Singapore IPO, that is the Intellectual Property Office. So it says a layout design of an integrated circuits refers essentially to the three-dimensional character of the elements and interconnection of an integrated circuit. This is what I was stating, that different layers are used for creating various circuits and functional circuits, and then they are connected. And IC is an electronic circuit in which elements of circuit are integrated into a medium and which function as a unit, which function as a whole. This chip, one chip will be doing one particular task. So this is how it is done. Because you see, the main difficulty when you look at the management of IC layout designs, especially in the context of, let's say, disputes, for example, the major difficulty is you can't see it easily. It's not something like a product. It's also not something like as physical as a drug formulation. It's something which is not, we say software is an abstract. But if you look at IC layout for a person who doesn't have any helping equipment, it's as abstract as anything else, because except that you can see the chip as a rectangular piece of metal or something of that kind. Next, please. Next. So going by the Indian law, what can be protected at IC? The earlier slide, please. Earlier slide.
Sir, कर दिया earlier ही है. This is earlier. You want one more before?
Then this is the one. This is the one. So if you suppose you come out with a IC layout design and you want to go to the patent office to protect it, what are they going to look at? Next, Vinita. First is your IC layout design should be original, okay? And it should not have been commercialized. Now, this is an important thing. It should not have been commercialized in India or any convention country for more than 2 years before filing the application. So what it really means is that it does not have to be a novel on the day on which you apply for a registration of an IC layout design. Like in case of patent, on that particular day, it has to be novel. Okay. Now, in this case, even if it has been in the market for 2 years, then within that period, if you apply for registration, it will be considered as original. Now, this concept actually does take place in case of registration of new plant variety. Then it should be inherently distinctive. It should be, that means it should look different from the things which are already there, and it should be, it's a well, a kind of a reputation inherently distinguishable from any other registered layout design. So this is part B of inherently distinctiveness, but it's the same concept. Next, please. Next, please. So, whenever you apply, since it is a matter which deals with law, so law will also prescribe certain ways in which you will have to apply for a registration, and that makes things much easier in case of any of the legal. Even when you apply for a registration of a house or registration of land, you have to fulfill certain formalities, and same happens in this case also. Or maybe you can say that since we are not familiar with IP, we think that it's complicated or cumbersome. It is not. Okay, so you have to, even when you submit an application to the office, you have to give the title of the design. Then you have to give 3 sets of drawings produced with a plotter. Plotter is a device for showing the pattern which you have generated on a wafer, which describes the layout design applied to for registration. And you have to apply 3 sets of photographs of masks used to fabricate. After you draw the pattern, you done the mask, and this mask is replicated on the wafer. So it's basically a process of producing IC circuits, and that these are the two requirements, and the size of the drawing or photograph shall not be less than 20 times of the size of IC fabricated during the or using this particular layout. So this is a condition, and you as a student or an academician, you may think these are not very important. Yes, from that point of view, it's not important. But if you don't meet this requirement, then the patent office or the registry for IC layout design, they are going to sort of turn down their application. So in order to save time, it's better to follow all the procedures. Next, please. Then you have to give classification of IC circuit, which can be manufactured using the layout design. What it really means, IC circuits also fall in many different categories. For example, you have to specify structures, whether it is a bipolar system or it is MOS system or it's optical IC, and what technique has been used to produce the IC, whether it is CMOS technology, which is stands for complementary metal oxide semiconductor, or TTL, transistor logic, and so on. Then you have to give the function, whether it is a logical function, whether it's a function of memory, whether it's a function of a processor which handles actually analyze data and come out with some results. And so you have to give brief description of the layout design, which basically would mean that you have to describe as to what you are planning to achieve with this IC, and you have to give whether layout design has been commercially exploited or not, and when it was exploited. Remember, this is an essential condition for application, that if it should not have been in the market for more than 2 years on the date of application. And then you have to submit 4 pieces of the semiconductor IC. Whatever IC you produce, you have to submit to the office. Next, please. So how does it go? How does it go? In the IC layout registry is one. Of course, you have to file an application. So you have filed an application. Then what happens? So examiner is going to look at your application and see whether you have met all the procedural aspects or not. You have given all the documents, etc., etc. And if not, the examiner is going to come back to you and say that, okay, you can correct your application in the following manner. And once you have made all the corrections and amendments, the application is accepted by the examiner. After that, examiner or the office is going to advertise this application in the official journal. Now, this is a practice which is followed in trademark, which is followed in design also, and which is followed in patents as well. So you advertise this application with all the details, and if there is somebody who wants to oppose the registration of this layout design, then that person can come back to the office and saying that, okay, for the following grounds, this should not be given. I want to oppose the registration of this particular application, and this has to be done within 3 months of advertisement. And once the advertisement has taken place, and suppose there is an opposition, the office is going to decide whether opposition is valid or not. And once the decision is taken, either yes or no, the applicant is informed accordingly. So if it's yes, that means opposition is not really valid. The application is approved. So the office is going to give you a certificate of registration for the said IC semiconductor IC layout design. So this is a procedure which is followed in respect of registration of grant of any IP you have seen, or whether it's trademark or copyright. Copyright, of course, falls in a little different category, but for all these things, you have this kind of a procedure. Next, please. So if suppose, since it is any IP is a monopoly right, is it's an exclusive right. So if somebody infringes your IC layout design, and if it's proved, then it can be an imprisonment up to 3 years and fine extending from 50,000 to rupees 10 lakh or both. That is for infringement. If you have knowingly or unknowingly is of course is handled in a much lenient manner, but if it's knowingly you have copied the thing, then this is the kind of punishment you can be given. But at the same time, there is a concept of falsification. That means if you have a non-registered layout design, which means you have some design and you have not gone for its registration, and you claim that this is a registered design, then it can attract an imprisonment of 6 months and a fine of rupees up to 50,000. That means it's a wrong declaration, and which is very unique feature in the layout design law. This feature does not exist either in the design law or the trademark law, where most of the counterfeiting is taking place. Next, please. Now, what is the term of protection for layout design? It is 10 years from the date of filing or from the date of first commercialization, which should not be more than 2 years from date of filing. So either situation. What are the rights conferred to you if you are given this registration, exclusive right to the use of layout, design, and obtain relief in respect of infringement, which is quite obvious that if you are given this right, but the law has got some other concepts built into it. For example, the registered user concept is there. I will not talk about it because it makes I think a little more complicated. But that is why obtain relief in respect of infringement is an important thing, which is given to the person who has got the IC layout design registered. Next, please. So having said that, and it should be now clear that to make any semiconductor device, okay, you need IC layout design, because these are the designs or the patterns which devise the layout of various electronic components one after the other. Then you come with a semiconductor device. So they're interlinked. They're absolutely interlinked. You cannot take away one from the other. Now, other things which are, I think, which I've already given you an indication, but it's better to go through them. These devices are manufactured in nanometer scale. Nanometer, you know what is the scale? It's very small and often built on multi-layer structure, which I've been telling you, making analysis of infringing product costly and time consuming. What it really means is that if suppose you find that a chip which is being sold in the market is violating your IP on semiconductor design. Now, normally you will have to prove, somebody will have to prove whether it is the same thing or not. So how do you prove it? See, in case of drugs and pharmaceuticals, there may be some data which is available, which you can access. There may be some actual application which is actually are in the market. But in this case, it's not like that. So what you have to do is basically take that alleged infringing piece of IC and then go back and find out whether it is a duplication of your IC or not. Now, this requires a reverse engineering, right? Which means you have to have process using, like, say, electron microscope, transmission microscope, X-ray spectrometer, and so many such very expensive devices to find out whether it is a copy of your IC or not. Which is, number one, it's very costly, and number two, it is very time consuming. So the idea of any manufacturer of semiconductor device would be to have a strategy, which does not easily allow duplication of the device. And number two, you will build in your claims, so to say, in such a manner that just by checking that particular claim, whether that claim is being infringed or not, you can actually predict about the whole semiconductor device. It becomes a little complex in the sense, I don't know whether you have talked about uh, patent claims and other things, but this is one feature of semiconductor devices which is very interesting and which is very different from what is applied in other cases. In other cases, such kind of reverse engineering is not required. Next, please.
Little bit exposure they have, not much in detail about claims, but they have been discussed.
They have been okay. So and there's no need for me to go into that.
It's not French for them. They know.
Okay, fine. Next, please.
Yeah. Sir, कर दिया?
Now, this I have already spoken about what the individual electronic components which are built into a single chip of semiconductor material, which is usually silicon. So typically, I've mentioned, but let me go through it again. Typically, an IC comprises of active elements, which would be transistors, diodes, switches. People who are conversant with electronics, they understand these things, and passive elements like resistor and capacitors. IC are broadly and commonly classified. One classification which I indicated at the time of the application, which you have to specify in your application, you have to, they normally fall under the category of microprocessor and memory. So, it's not like, maybe in the college you have designed a circuit, you're connected wires, and through wires, resistor, transistor, other things, and then, or for that matter, even PCB, printed circuit boards, you see all kinds of things, they're connected with wires, but they are component taken as such. But in this case, what happens is on the semiconductor wafer is a sheet of silicon, which is a semiconductor, which has been processed in such a way that it is able to carry electricity under certain conditions. And this wafer, when you take this wafer and during the fabrication stage itself, you go on creating various elements. Like you will create transistor in the wafer, you create a resistor in the wafer, you'll create a switch in the wafer, you'll create an operational amplifier on the wafer. So everything is being created, and that is why it becomes a very, very complex fabrication and manufacturing technique. And as you know, that in India, we have only one facility which makes semiconductor or chip. Most of the Indian players, whether startups or otherwise, they go and get their chips fabricated either in Taiwan or Korea or maybe in China. But most people go to Taiwan because that is the cheapest option available among various countries. And once you make these, once you put these elements on the wafer, then they are not separable. You cannot take, okay, this is my transistor, I take it out, replace it with something. No, that does not happen. So that is why, when one of your devices in the house goes bad, the person will go, oh, iska chip badalna padega. So that's what they mean, our motherboard badalna padega. So these are basically the concept which go to say that this technology in design, in manufacturing, and even in use is quite different from what we normally see. Next, please. So with what are different models are being followed by the industry. One is called the integrated device manufacturing, which was the earlier days, starting from 1960s going up to 1980s, where one company itself will design your IC layout and also manufacture the device. But then this became a little complicated because depending on the market needs, the manufacturing process had to undergo a lot of changes and very quickly. So they thought that manufacturing agencies have to be separate. For example, Texas Instrument is a good example of integrated device manufacturing, or Micron for that matter. Then they have the fabless, which means fabless are the people who will actually design the IC. They don't manufacture. They design the IC, put everything, whatever necessary is there, then giving to the manufacturing person, and which are normally called foundry now. And these foundries are going to produce your IC circuits. So when you look at these different industries and when you look at the literature, you find that most of the protection which is sought by these industries to protect their IC layout design would be patents, trade secrets, and copyrights. So, and of course the IC layout design, but I've not mentioned IC layout design because many countries don't have similar laws. But if there, then you can put IC layout design as well. So, and of course, trademark and trademark will come automatically a little later when you actually start marketing your product. Next, please. Now, these are the top or leading semiconductor device industries: Intel, Texas Instruments, IBM, Micron, Broadcom, and these are the people who are actually having many of them. Many of them are actually the manufacturing facilities, and many of them are not. Like IBM, I don't think they manufacture IC layout in IC circuits as such. But Broadcom and Texas, they're into this game. And Intel is also there. Then, of course, like for example, take Qualcomm. Now, Qualcomm has got a very interesting licensing and valuation policy in the sense that Qualcomm is only a fabless. It actually designs these ICs, and for manufacturing it, they give it to someone else, right? So it's a good example of fabless Qualcomm. And when you are talking about this kind of a model where you have a fabless and you have got a foundry, and then this foundry can actually outsource some of the activities. Similarly, Qualcomm need not actually design everything on its own. It can also outsource. And once so many outsourcing are taking place, the chances of infringement also go up. And this is one of the big risks when you are dealing with these devices and IC layout design. And hence, a company has to really define the strategies which it's going to follow in terms of to avoid copying, or what we call as counterfeiting, and then see what is the best. If companies are not able to define their strategies properly, they suffer as well, because then somebody in the industry can copy your semiconductors. Next, please. So, what are the possible IP included in software-related technology? As I mentioned, that whenever we talk about digital technologies, software has an important part. So these are the different things or IP routes which these companies may take. Patents, know-how is something which is basically your manufacturing processes or your design methodology, design philosophy, codes, source and object code related to software. And we have trade secrets, as I mentioned. This is one of, and I'll give you an example how these companies actually go into protecting trade secrets. Then manufacturing with trade secrets will include manufacturing know-how, chemical formulations, chip design, and so on. Chemical formulation, because all this connectivity which takes place on the wafer, they would be through some chemical etching process and other things. Then you have got the library. They've got the library of various codes and other things which you have with you. Then bug fixing is another area which is important. You'll see an example what Google have been facing: algorithms, software, and hardware design. So all these things are there, and some of them may fall in patents. Some of them you can follow copyrights. Trade secrets are straightforward. Some of the things may be maybe IC layout design. Next, please. Now, there has been a lot of confusion about whether software can be patented in India or not. I was listening to the earlier lecture also, and some question was formed, asked on this subject. Historically in India, we had taken a view. Since I was a part of it in late 90s, when we were discussing software patents at that time, we didn't have software industries in our country, and our our concept of software was basically to solve mathematical problems, starting with quadratic equation to matrix inversion. And we were not really aware that software can be used for all this, industrial purposes. So there has been a little thing that somebody mentioned about Section 3K, software per se cannot be patented. It has been a question of dispute, interpretation, and whatnot. But this particular slide uh, tells you that the Intellectual Property Appellation Board has given some guidelines. So what it says, if first of all, important thing is your software should be associated with a hardware. Okay, that's very important. Software standing all alone on its legs is not patentable. But if it's linked to hardware, then what are the parameters which should be used to find out whether that software should be patentable or not? Vinita, we have time?
Yeah, we have time. We have half an hour.
Okay, so we have, the parameters would be higher speed. So if software leads to a higher speed of, let's say, if you put your software in a manufacturing processes, reduced hard disk access time, more economical use of memory, more efficient database search strategy, more effective data compression techniques, improved user interface, better control of robotic arm for that matter. This is a good example to see whether the software, the relationship between software and the hardware. But the other things are extremely important, and people who are studying computer science or who are teaching computer science, you know that what is the importance of the database itself. Data itself is so important. How do you organize it? And not only in a static term, but also in dynamic terms, which is a subject by itself. I am not competent to speak on that subject as such, but I do appreciate what it really means. And if you design your database in such a way that it is unique, first of all, in the sense such databases are not seen, and this database is so arranged, so organized that you can pick up data and use it for your particular application, then the database itself can lead you to a grant of a patent. So today, as far as India is concerned, software patents are not the things of past. Every day, I think the whole cycle of patent examiners and law judges, court, everybody is going to change. And we perhaps, I would imagine that next 5 to 10 years, we should be having the same kind of laws and interpretation as we have in US, or for that matter in Europe. Next, please. No, so these are things which are linked uh, uh, in major way. And let me give you a few examples, because one can't go into very highly technical matters. So there are examples how to value a patent, which was a subject matter of the earlier lecture. So you normally go by the experience, what happens in the market. Now, Nortel Network, they sold their patent to Microsoft, Apple, and this was a consortium. And there were 4,500 patents which were sold for, there were 6,000 patents which were sold for 4,500 million. On average, each patent was valuing $7,550,000. And these patents also had patent patents which were standard essential patents. We'll come to that a little later. Then Motorola sold its large portfolio of patents, like something like close to 25,000 to Google, and they were sold for 12,000 million, and each patent cost about, just simple division if you do, it's not the right way, but just to get a feel that each patent was worth like $500,000. Now, in your lectures now and earlier lectures also, you will find that as Indian industry or Indian researcher, we are not able to think on these numbers, such large numbers. And this is the global reality. And if you really want to become a good global player, then it is necessary that our invention should be of that order. Similarly, novel sold some 800, 900 patents, and it was again the same value of $500,000. So this may be a good number, which researchers can really keep in mind and build around that. Is it, if we collect data and it's a, can we say that average value of a good software patent would be $500,000? And when you do this valuation exercise, you would normally do an iteration. Based on this starting number, you can do number of other iterations. Next, please. So this is another area, another set of data which talks about software patents transfers, and you see the number of patents with IBM has given as transferred to global foundries. Global foundry is the same thing with, remember I mentioned about foundry. These are the people who make IC circuits, fabricate semiconductor devices, and this is where they went about, and they charge a whole lot of money, so many $billions. And if you can, the other interesting thing you must see that LinkedIn, Twitter, and Facebook, they have relied very heavily on patents transferred from IBM to them. So they may be good. They were a good startup at some point of time, but they depended a lot on the licensing of patents, basic patents from IBM to them, and happened in case of Lenovo also. So these numbers are there. The numbers give you just a feel. Next, please. Now, this was a study which was done in US by the National Economic Bureau or something like that, which is a government of US agency. And they looked at computer and semiconductor industries, and they found that in the semiconductor and computer industry, they rely a lot on, one is on blocking in the sense, but not as compared to drugs, but they are interested in negotiation. That means for cross licensing, their patents are so designed that they can cross license to each other. Term must have been explained to you. So when you look at the earlier data, when IBM transfers some patents to Facebook, but still there will be some element of cross-linking. So these industries are depending a huge lot on negotiation, cross-licensing. That is one thing. The second thing is they want to prevent legal suits, so that they don't have to go to the court. So, and the other thing is they want to maintain secrecy. So these are certain things which are very unique for computers and semiconductor industry, which is everybody wants to have secrecy. There's no doubt about it. But some people, some industries are more prone to it in the sense they want to keep it very secret because the risks which are involved and the cost of copying and cost of marketing itself becomes a major impediment for the industry which has actually innovated or invented or for the first time made the semiconductor device. Next, please. So this is what I was saying. So computer and semiconductor industries, they rely very heavily on secrecy. That is trade secret, which I mentioned, which would be manufacturing know-how, chemical formulations, it could be software, then patents and lead time. Now, lead time is something which is very important from the marketing and business point of view. So their emphasis would be a, let's say, I wouldn't say a compromise, but adjustment between the complexity of a patent and the pace at which they can enter the market. So if the patent is very complex to implement and it delays the entry into the market, then the option would be select something which does not disturb the lead time for your product into the market. So it is also, this is not a case for drug and pharmaceutical industry so much. Then of course, it depends on the complementary aspects like sales and services and manufacturing. So what I'm trying to say is uh, IC layout, which is an integral part of semiconductor devices, has got certain unique feature. And these features have to be kept in mind. And whosoever is studying the subject, you have to really read it and understand what is happening, because because of the piracy in the IC, semiconductor devices, and whole strategic and defense industry is coming into challenge. You can have a IC circuit chip which is available to you at $5. The original chip may be $100, but this $2 chip can fail after few hours, or it may not give you right results. So it's a big issue. And in fact, in US, this thing is being discussed at a very, very high level to see how you look at semiconductor devices and their infringement. Because if you look at the any defense technology, even for matter defense, it will be full of ICs, full of VLSI and full of ICs. Now imagine if you buy some IC from a vendor and you fix in the aircraft and it fails maybe at the nick of the time, or maybe after a few hours, then your whole preparation for the fight or war is lost. So sensitive, very sensitive also, semiconductor devices in this kind of industry. Next, please. Next. So these are, looking at AI, is something, these are the various areas which are, I've given the word AI, but it can be true for even the other industries also, because AI means basically you're looking at very large databases, speech processing and distributed AI, natural NLPs, robotics, computer vision, machine learning, and so on. Next, please. Machine learning, that is one of the major areas. In fact, if you look at the AI area as such, within the AI area, the maximum number of patents which have been filed are in the area of machine learning. If you really look at the Indian situation, even for machine learning, if you want to implement a machine learning software, you must have the semiconductor devices and other things to really implement it. India figures nowhere as far as the patents are concerned in the area of AI, whether it is machine language, NLP, or IoT. But I was reading some literature, and we find that at least in terms of publication, India does rank somewhere in the first 10 countries when you talk about publication in the area of machine learning. So you guys are smart guys. Google Map is a very good example of machine learning, how it is able to give you the time required to reach your destination based on data, which is on traffic condition, speed limits, road size, and many other factors. Next, please. Next. Machine learning essentials. All of people who are working in the area dealing with big data. It deals with data collection, data storage, data preparation, algorithm training, application development. And if you really convert these things into IP platforms, everywhere you will have a scope of protecting it through intellectual property rights, except you can say data collection. But data collection, whatever methodology you use for data collection, because the data has to come from multiple sources. It may be in multiple forms, like it could be text, it could be sound, it could be images, it could be a combination of them, so many things. But your methodology which you use for collecting data is a subject matter of trade secret, because you'll not like to tell anybody how you are collecting the data, because that's your something up your sleeves. And especially if you are looking at data which is of the size of petabyte, then this methodology become very important. Data storage, what kind of data metrics you have designed for getting the data, and then converting this unscrambled or scrambled data into unscrambled data. That means the data which you receive from various sources, as all of us know how it is happening, then put it into a form or a matrix or an array which is useful to your application, becomes a subject matter of, again, copyright. It can be a subject matter of maybe even a patent, if you feed it well into your software, then algorithm training, the data has to be trained again and again till you get the right kind of output. You can't have a trainer which gives you wrong results, and application development. So these are the things, but the point which you must remember that it's not a lecture on machine learning, but it's basically indicating the relationship between IC layout design and various technologies which we see today. Next, please. So these are the likely areas of innovation: structure of the model, training process, input data preparation, input data mapping, post-processing and interpretation of output data from the model. So everything which goes on there, for implementing it, you will have somewhere a semiconductor sitting, and when some semiconductor is sitting somewhere, it will also have the IC layout design. So this is how the relationship is there. So you'll have to really think in terms of the final product or the final invention, where all these things are playing their role either independently or in a team sense, they're playing their roles. Next, please. So these are some economic figures, and this is the talk about how much investment is being made in the AI, and I think we can skip this slide, Vinita. Now, big data is something which I don't want to educate the students, but big data is something, if you're talking about 10 to the power 12 bytes, which is still less than exabyte, and soon we are going to go into the exabyte domain, then handling this kind of data is not something which is very easy. We are still in the domain of something like a million or perhaps a billion data, not beyond that. And you know the kind of technological development which are taking place, including quantum computers. These things are going to become a little easier, but all these areas, if you want to really take a market lead, if you want to make money out of your invention, then you have to be conversant with the IP thing, because without the IP, it becomes very difficult. At the same time, we should remember that one IP cannot define a product. A product will have multiple IPs. And once we talk about multiple IPs, then there should be a system for dealing with multiple IPs, because all these IPs will not be owned by one company, as I mentioned, in complex technology. So if you are going to have many players entering into the same product, there has to be system for licensing of the IP. As I mentioned, cross-licensing is one of the most important way of these industries to talk to each other. Next, please. So this is something on jet engine, how many sensors you have today to measure, 50,000. I'm basically an aeronautics chap. So I could never think that an aircraft engine can have 50,000 sensors to record various temperatures and other things, and how much time it saves and how much safety it increases for the aircraft. Next, please. Next. इससे पहले वाली क्या थी? Yes, this is something which may interest people. Somebody in Google mentioned that when they have a software, Google's software which contains 2 billion lines of coding, okay, or Linux has got 20 million lines of coding, and Microsoft Windows has 50 million lines. Now, when you talk about such a large software program, there's a possibility of making error. So you are talking in terms of 10 to 50 errors per 1,000 lines. And that's where from here you can anticipate what is the importance of accuracy, what is the cost of making errors. And hence, when you go to the market, because market you can't afford this kind of 50 errors or 100 errors in 1000 lines. But these are the challenges. These are the challenges. And therefore, whatever you do, each small thing, and that's where the software packages, software industry becomes so expensive, because a lot of human resources, the money goes in developing a software. Let's say, for example, the Google software of 2 billion lines, which is a reliable software. Just to highlight this point, because many times this data is not available. So you get this data because you're reading some book and suddenly say somebody has talked about it. So you capture it. I keep sharing such data. Next, please. Then, of course, Internet of Things is there. I will not go in Internet of Things what these are. We have already spoken about it. But when Internet of Things will become a real success in the 5G technology frame. But of course, Internet of Things are being used even today also. But it's again, its efficiency, the productivity, the safety, and other things will increase once the 5G networking is in place. Next, please. Next. So interestingly, you find that a lot of patent applications are being filed in India in the area of IoT. This was a study done by NASSCOM, which says between 2009 to 2019, that is a period of 10 years, 6,000 IoT related patents were filed. 40% of these have been granted. 90% of the granted patents were filed by MNCs, and 95% patents related to hardware. Please note that, because you see, often we are led into a path where we only talk about software. We don't talk about hardware. Software is important. At the same time, we should recognize the importance of hardware. Next, please. So these are some examples of licensing of IoT. Since these slides are going to be with you, Vinita will share with you, then you can look at these numbers. There's no point reading the numbers, but one thing is definitely there, that all patents which have got standards associated with them, they are licensed at a much higher rate. Next. So these are certain things that Samsung is doing pretty well in the area of IoT. It acquired a company called SmartThing for $200 million only, and SmartThing did not even have any patents. And if you compare with other licensing where it goes in terms of billions of dollars, all these transfers took place at this cost because the selling company had got a large portfolio of patents or some other IPs. Normally, trade secret IPs, you're not able to define them as distinctly as a patent. But so somebody asked about startups. Now, startups have a problem in India, and the problem with the startup is they normally don't believe in patent filing and getting patents. And there was an IBM study which was done, I think about 4 years back. We said after 2 to 3 years, 95% of the startups pack up because they don't have any USP. And USP comes from your IP holding. Okay, and IP holding is important because then you're able to compete with others, or you check the entry of your competitors. Next, please. Okay, and these are some acquisition of IoT patents. You can see that the market of IoT patents, transaction market of IoT patents, is also actually swelling up. And with passage of time, you'll be seeing more acquisitions and of IoT patents. Next, please. Now, a little bit about the standard essential technologies patents. Some of you may be aware that whenever a product of kind like a smartphone, or even for that matter, a phone which is depending on 2G or 3G, there are a lot of functions, there are a lot of application functions which are standardized. That means whole technologies, the technologies which goes into manufacturing of these phones, mobile phones to start with, they have to be standard. Standardized means basically interoperability. For example, now example of interoperability will be you're sitting in, let's say, Noida, and you're talking to a person in Chennai without any loss of clarity or signal and other things, provided your base stations are doing well. And there are many examples of this thing. And you can go to, for example, you make a call from here to US. Somebody may be in Qualcomm system, you may be on GSM system, but still you are able to talk. So these things are taken care of by standards. And in this domain of technologies, most standards actually is the reverse of what happens in other area of technology. Here, people file patents first to meet an actual need, which the companies decide, companies actually formulate through their marketing team and other, and these patents are used to develop standards for the technology. So it's a little in other cases it is other way around. First you develop the standard, and then the technologies will come. Somewhere some interrelationship is there. But in this case, you look at all these things, whether you are looking at Wi-Fi, whether you're looking at Bluetooth technology, GPS system, memory systems, near field communication system, and you'll be surprised. Can you go to the next page? You'll be surprised that standard formulation for these technologies have taken maybe varying between 10 to 30 years, maybe 10 to 30 years. So it is essential for people who are working in this area of semiconductors and ICs and IoT kind of a thing, of course, where software also become important, to look at SEPs very, very carefully. And these SEPs, you will see when you read the literature, you will find that the licensing or valuation of patents, which are the SEPs, it is much larger than the patents without SEP, of course, in the relevant technology area. So I have given something, for example, wireless standards are essential for connecting devices and are followed by chip companies, telecom companies, and cellular carriers. Now, for example, we are talking about, that Fitbit band is there, you are recording many data, and this kind of thing is also used for monitoring the health of patients, and this data go to the cloud and then it is analyzed. So all these things are they're essentials. The evaluation method for technology developed for the standard has little market value outside, so they are specifically related to that particular application, but it may happen that it can be applied to other areas. Next, please. So this is some examples of IoT standards. Zigbee is one standard which is meant for home automation, which is developed by IEEE. Bluetooth standard for wearable devices. Ultra narrow band weightless standard, again by IEEE, and so on. There are so many standards. So people who are working in this area, they'll have to keep this thing in mind, because if you do an invention which does not meet any standard, then your invention will take many years to come to the market. Next, please. Next, please.
Perhaps we have come to the end. Yeah.
This is all I wanted to share. I think it was not flowing in a very good streamline, because the subject is a little complex, but nonetheless.
Explained in a very simple language. I really liked it, and I'm sure the audience have also understood it, because lesser talk things they should generate more interest.
So if there are questions and if there is time, then I'm prepared to.
Yeah, there is time. I think you finished very much well in time. Okay, audience, the floor is open. Could you please ask questions? You have any question? Are you hungry? I think is any possible collaborating? There are questions. I'll just read it out. Sir, just give me 2 minutes. Very informative, that is a compliment. If novelty lies in software only is enough, or novelty in hardware is must for patent?
No, novelty in hardware is not essential.
Okay.
If your software is novel and that is attached or that is doing something with the hardware, then software itself will become patentable.
Okay,
In
so
fact,
Vinay Shankar, are you there? It's your question being addressed. Hello? Okay, seems I muted them. Just let me check. Allow attendees to unmute. Okay. Sorry, I had muted them. Vinay? Hello? Mr. Vinay? Okay, maybe he's not there. Anyway, I'll go on to the next question. Sir, is there any possibility in collaborating in patenting with the management faculty in mechanical devices? What? Is there any possibility in collaborating in patenting? This is
well,
this is not a
maybe,
part. This
maybe
is not a part. Another question is, can two or more can get patents for a single product?
yes.
Yes.
You can be joint inventors. This is allowed by law. The important thing is that you have to see that your name is included in the patent application. Okay, then only your rights will be there. Yes, the simple answer to your question would be yes, there could be joint inventors. But another important thing which you should realize, which is allowed by the Patent Act, that each inventor, okay, can use this invention for his or her own purpose. So you can actually set up 3 different industries if you have common inventor and without taking permission from each other. That is a possibility which exists.
Next
Right?
is
If
there
you are
is there any difference between vessel hull protection and semiconductor chip protection?
between the thought of the first word,
Between vessel hull protection,
vessel hull.
and
Oh,
semiconductor chip protection.
uh, see, vessel hull is a very traditional subject matter, which would largely fall in the structural and mechanical engineering. Yes, but as I mentioned, yes, patent law applies in the same manner as to vessel hull or to the semiconductor device. So when an application for semiconductor device is being considered, the examiner is going to look in whether it is novel or not, whether it is inventive or not, whether it has got a utility item or whether it's functional aspect. And same 3 cardinal principles will be used by looking at the application for vessel hull. Okay, so if you feel that through my talk, it is basically the post-patent, post-IP situation when you handle the things a little different. But otherwise, same principles. No distinction on that. But you have to realize that for each technology, the novelty parameters are going to be assessed in a different manner. Same and more than that, inventiveness. Because what is happening today is novelty is, I would say, generally taken care of. Not, I won't say all the time. And among the Indian inventors, it's not true, but yes, I can say that novelty is generally people look into it. But inventiveness is something more than novelty, which is very important because there you have to use the gray matter much more to find out whether your invention is novel and inventive or not, or whether it is simple extension of something what is already known. And since you are asked this question, and I'd like to share my experience that I'm looking at a large number of cases dealing with inventions by startups and SME, and what I generally find that people are quite weak uh, while determining the novelty because they don't want to take the trouble or hard work of going through patent literature, which I think there was a lecture on patent searches. And that's a hard work, a time consuming work. But that is the only way, because if you don't do it, well, patent office may even grant you patent because patent office is not supposed to check your novelty. They are going to check what you have told them. Based on that, they are going to assess whether your invention is novel or not.
Okay, sir. I think now rest is compliments. So anybody who wants to ask directly, you can use your mic and interact. We still have 4-5 minutes. So I think there's no response now.
Yeah.
May I ask one question?
Oh, definitely.
So you were talking about user interface, say for example, on a website or on a mobile phone app. If I came up with some sort of layout and some sort of interface, how can I protect from other? Can it be protected?
Yes, it can be protected in principle, but and the question will be whether you would like to protect it through patent or copyright. Okay. So my suggestions to all of you is then don't hesitate to protect it in the copyright. Okay, that's a very, very powerful system. But if you want to get a patent on that interface, or as you say, apps, then you will have to see whether these three principles are met: novelty, inventiveness, and utility. That's very important. Secondly, with this interface, what is happening to your hardware or final application? In what manner? You can say it's a new application. Okay, a new application will have a dubious case. But if you have something to say that you have already was something there, and because of and the absence of interface, that there was loss of application time or memory or something like that, then it has got a better chance of getting patents. But I would think that you people should also explore the possibility of filing a software copyright application.
Thank you, sir.
Any more questions? Any more questions, or else we'll wrap up? I don't think so. Sir, आपका ये camera, is it getting on? The camera? Try it, sir.
वो स्विच ऑन हो ही नहीं रहा, तुमने क्या कर दिया?
Okay, मैंने कुछ नहीं किया. मैंने क्या किया?
ऑन हो नहीं रहा वो.
हाँ, कोई बात नहीं sir. Okay, so we'll just since there is no more question.
No, it is on. Now it is on.
Okay.
Now it is on.
That's fine. We need one print screen capture for all the sessions. So I requested you to open it. So thank you, sir. Thank you. Thanks a lot for giving your time and discussing on a timely yet a very obscure, it seems, lesser known, because there's no uniformity, there's no harmony in its law. So we can only expect that if our audience could generate more interest by incorporating this in their teaching style or research, etc. And I was very impressed with the data, a lot of data you shared with us from the research paper. So thank you once again for this wonderful session. I'm sure the audience have enlightened themselves. Thank you, sir.
Thank you very much. Thank you all.